Okay, welcome everyone. I appreciate those of you that have taken time to participate in this webinar about financial wellness. Uh, my name is Gordon Holmes, and I am a special needs financial planner. My practice focuses on assisting families that have members with special needs with the legal, financial, and government benefit issues involved. And we will take time during the webinar to address all of those, the legal, financial, and government benefit issues involved in having a child or dependent with special needs. What I'd like to do is review the items, the handout items that you have there. And so let's see. Okay. Okay, I'm getting some help here. Here we go. Okay. The first handout is my practice brochure, and it's a two-sided form. On the front side is a little picture of a kid with Down syndrome, a young boy with Down syndrome. I just love the picture with the clasped hands and that look of hope and optimism in his eyes. In the center section are my office locations. I have an office here in Indianapolis and an office in Louisville. And through both of the offices, we help families or assist families throughout the entire state of Indiana and most of Kentucky as well. There's a website, email, toll-free number, all the typical contact information, and then of course I have a team that supports my efforts, and certainly very much appreciate their help as we seek to assist families with these complicated issues. On the other side is a picture of my family, and I have 3 children, the youngest of which, Matthew, has special needs, and so my journey with special needs began close to 20 years ago, and so I embrace special needs both personally and professionally, and therefore the reason for my special needs practice growing over these many years. Also on that side is just a smattering of some of the organizations that we work with throughout Indiana and Kentucky. A lot of school corporations, nonprofit organizations, support groups, etc., and a bit of a narrative about my personal journey. The other attachment has to do with MassMutual Special Care. And MassMutual, by the way, Special Care is a combination of what previously had been MetLife's Center for Special Needs Planning and MassMutual Special Care. And so we're actually a nationwide network of trained specialists that work in special needs. And so I'm one of, I think, close to 400 financial advisors across the United States. And so we're quite a passionate group helping families in our respective communities. We'll now turn our attention to the PowerPoint. And so hopefully you can make your way to the slides that are part of the PowerPoint, and we'll start with that. So the lead slide, your dependent with special needs, making their future more secure. And our focus in the practice certainly is that participating in the journey to make the future for our loved ones with special needs all that it can be. As it indicates here, what's important to you as a caregiver, as the caretaker of a dependent with special needs, you're looking after their best interest. That's why you're participating in this webinar. That's why you participate with Down Syndrome Indiana. probably sit in on IEP meetings and a host of other things that you do for them. But the question that looms heavy for parents like us that have a child or children with special needs is what happens when we're not around. And especially as our kids get a little older and we get a little older, the question does loom and is a substantial concern for many families, because usually there's a good deal of accommodation involved in having a child or dependent with special needs, and we're of course all concerned with how all of what we have worked so hard to piece together in the way of government benefits and other supports and again accommodations, etc., how all of that will continue or not if something happens to us. And so that will be a part of our focus with the webinar today. On the next slide, there are 3 questions, and the title is do you know if you have planned effectively for your dependent with special needs? And okay, fantastic. Just a little IT bobble there. I'm sure many of you can appreciate that. But 3 questions. So do you know if you've planned effectively for your special needs dependent? And the 3 questions are just fairly basic yes/no questions, and they're designed to be a measuring stick on planning that you may have done or kind of where things stand in the planning process. So the first question is, have you left more than $2,000 to your dependent with special needs in your will or trust? Children with special needs typically require additional resources, or we could say perhaps are a little more expensive than others. And so question 1 focuses on how resources have been arranged or provided in your estate plan relative to your child or dependent with special needs. Number 2, have you identified that brave family member or close friend who will be a guardian or care provider for your child or dependent with special needs if you're no longer here? And number 3, from a beneficiary standpoint, for many of us, if something happened to us, most of what we leave for those that we love, perhaps a spouse or our children, is left in the form of life insurance and or retirement accounts. Group life insurance, perhaps through an employer, perhaps a term policy that we've picked up on the side, a life policy that our parents took out on us when we were younger, maybe some insurance through the credit union or some supplemental plan through an association, etc. So again, life insurance comes from a variety of sources, as does retirement accounts, whether it's a 401k or a 403b, whether it's PERF, whether it's a Roth or a traditional IRA, or an annuity, this type of thing. All various retirement accounts that are patchwork together to try to help fund our future when we're no longer working. All of these, again, life insurance and retirement accounts, are typically controlled by beneficiary designations. And so the question number 3 is, has your dependent or child with special needs been included? And that's because frequently people are hesitant, reticent, slow, kind of get around to updating beneficiaries as families expand or change, that type of thing. And so frequently dependents can be left out and beneficiary designations are out of date. And so question number 3 deals with that issue, specifically relating to child or dependent with special needs. Now, these 3 questions actually embody most of the special needs planning process. And so getting these questions right is really important. And it would seem that to ace the exam or to get all the right answers would mean being able to answer yes to each of the 3 questions we just reviewed. But what's interesting is if a family's train, so to speak, is heading down the track and special needs is not a part of their journey, answering yes to all of these 3 questions, probably a good thing. Money for the kids, someone to take care of them, and everyone listed as a beneficiary. However, when that caboose called special needs gets attached to our train, all of the answers change. And interestingly enough, if there is a child or dependent with special needs, answering yes to any of the 3 questions actually indicates a need for additional planning or potentially trouble ahead. And we'll take these questions one at a time, and we'll talk about why having a child or dependent with special needs changes the dynamic as it relates to them. We'll look at things from a legal and a financial perspective. One of the challenges for families with special needs planning is that it requires a team. And specifically, that's someone from the legal community that has expertise in special needs, and also a financial planner like myself with expertise from a financial perspective. And so usually what works best with special needs planning is this teaming effect with an attorney with expertise in special needs, and again a financial planner or advisor also with expertise in special needs, working together collaboratively to help a family get through the legal and financial issues related to special needs planning. I'm pleased to say that over the last 20 years I have developed strategic alliances with a group of attorneys throughout Indiana and Kentucky, so that as we work with families, we do utilize the teaming approach and address things both thoroughly from a legal as well as financial perspective. Let's start on the legal side, and we'll touch briefly on wills, trusts, and we'll talk just a little bit about guardianship. As far as wills are concerned, and by the way, we are on slide number 8. That is, there's an 8 at the bottom of the slide that I'm currently addressing to be helpful in tracking along. So slide 8 says what I need to know about my will. So first of all, why I need one. What motivates most of us to get a will? And there are several reasons. One is sometimes just perhaps losing a parent or grandparent or friend, coming face to face with death and being reminded of our own mortality. That can be a factor in the desire or motivation to get a will. Second, having children, getting married, that is, significant life changes frequently prompt people to consider getting a will, because now there are people that depend upon you or that you want to make a provision for if something happens to you, and a will is essential in that process. Also, you may have specific items that you want to go to certain people, whether it's a collection, perhaps a gun collection, or some jewelry, or mementos, or family heirlooms, or antiques, or maybe musical instruments or the such. All of these are examples of items that sometimes people want to make a special provision for, so that they go to certain individuals that will appreciate them and enjoy them. There's also a desire on many people's part to have a say as to where minor children may go to, or adult children for whom they have gone to court to obtain adult guardianship. And so your will is the vehicle. It is the way to let it be known what your wishes are for where children or adults that you have guardianship for will go to. That is, who will provide for them, who will care for them or be the guardian for them in the event of your departure. In addition to that, your will provides you with the opportunity to decide who's going to be in charge at the time of your death. And that's what we call the executor. And the executor's role is that of handling your property and your affairs in your absence, filing your final income tax return or return for your estate, paying your utilities, liquidating your property, paying your bills, perhaps dealing with arrangements and expenses related to your burial. There's a lot that an executor does, and if you have a will, you get to choose who's going to be in charge and handle those things if or when something happens to you. So a will is relatively inexpensive, and as you can tell, it does so much. And again, an essential tool in the estate planning process, special needs or not. But when one has a child or dependent with special needs, the will becomes all the more critical. Let's move on from slide 8 to slide 9, and we'll talk a little bit about trusts. It wasn't that many years ago that if someone mentioned they had a trust or their family had a trust, that we would typically associate that with people of wealth. And that's to a certain degree true, that trusts were vehicles used by the wealthy. We read about them in magazines such as Time or Life or Newsweek or People magazine, this type of thing. But like so many things that perhaps were the playground of the wealthy or were expensive at one time, trusts have become very commonplace today and have become affordable by the masses. And as a result of that, more and more people are using trusts or incorporating trusts into their estate plan. So you might say, why? What does a trust do that I can't accomplish with my will? Well, with your will, you pick an executor, you decide who gets your stuff, this type of thing, the guardian for your children, etc. A trust is an opportunity to take things further, especially from a financial perspective. With a trust, you can not only decide who gets what, but you can decide when they get it, actually create a schedule. Perhaps it's a certain age they need to be, or they need to be at a certain level of accomplishment to receive their inheritance. You can decide what the funds will or will not be spent on, so it provides you with a huge say after you're gone. And a trust can also protect your legacy, to see that it's used for purposes that are consistent with your value system, and also make sure that what you leave is not squandered or wasted, but instead helps accomplish great things for those that you love. So again, trusts have become very popular, and with a trust you get to pick a trustee, and that's the person that's in charge of whatever you leave to a trust. So just like an executor oversees things from the perspective of your will, the trustee oversees whatever you have left to the trust. And the conclusion one may draw right away is, I don't have that much, so I obviously don't need a trust. However, many people don't have much of anything to put in a trust, and in fact the trust gets funded with assets that they leave at the time of their death, and that can even include life insurance or retirement funds. And so trusts can be useful even for individuals that do not have significant net worth while they're here, and a trust can be listed as the beneficiary, again on life insurance or retirement accounts. that then can fund the trust at the time of a person's death. So a trust can be set up relatively inexpensively, and it's not necessary to put anything in the trust today. It can be funded down the road, even as late as at the time of your death. So trusts have become very popular, special needs or not, to, again, make sure that funds are not squandered, that there's some oversight and responsibility in how your legacy is handled. So we're going to build on some of what we've talked about thus far, and especially as it relates to trusts from a special needs perspective. Let's come back to the three questions that we posed earlier. The first question had to do with leaving resources in a will or a trust for a dependent with special needs. And it seems to be a bit of a conundrum, because we agree that our child or children with special needs need more help. They frequently need more resources. And yet we're saying that it's a problem to leave assets or resources to them. So in essence, the one that needs the most help, we can't help. Well, many parents found this frustrating, especially as children are, on a long-term basis, frequently cared for and in one's family home, etc., and less, so to speak, leaning on what the government can do, and families trying to be more helpful. And so this actually is due to how government benefits are often constructed relative to eligibility requirements. So in question one, $2,000 is specifically listed, and many of you are probably aware that $2,000 happens to be the threshold, certainly in the state of Indiana and Kentucky as well, for eligibility for both SSI, which is supplemental security income, a monthly stipend for food and shelter, as well as Medicaid and therefore Medicaid waiver services. So if an individual with special needs, personal assets or resources, checking, savings, an investment account, government bonds, a UTMA or Uniform Transfer to Minor Act account, or a custodial account, an account that whose registration bears their name, that is set up in their Social Security number, where tax reporting is under their tax ID number. All of these are indicators of assets or resources that are attached to or associated with the individual that has special needs. And when those collectively reach $2,000, in most cases, a person becomes ineligible for the benefits we just talked about. That is, they become ineligible for SSI, Medicaid, and Medicaid waiver services as a result of that. And that does include disability Medicaid, which funds the Medicaid waivers. So at $2,000, they lose most everything. So therefore the conundrum, gosh, the daughter or the son that I want to help, that I want to leave resources for to help preserve quality of life for them, to supplement what government benefits we might have in place. In essence, the government is saying, if you help them, we won't. Now the stakes are high, because these government benefits, especially over a lifetime, can be worth literally hundreds of thousands of dollars. And it would be a significant yoke on parents or on a family to attempt to leave sufficient resources to pay all that Medicaid would have otherwise paid, or the waiver would have provided in the way of services, or Social Security would have provided in the way of monthly income. And so realizing this, families decades ago lobbied Congress, and we owe a great debt to them, because there was legislation passed in the late 80s and early 90s that brought about something called special needs trusts. So you may have only heard about special needs trusts recently, but they've actually been around for probably 25 years or so. And special needs trusts are a special type of trust. Now, we've talked about trusts already, the opportunity to exercise some control over your assets after you're gone, to put a trustee in place to follow your directions, to see that your values are respected, that funds are used in a manner consistent with what you want, not wasted, etc. Well, when it comes to a special needs trust, it's again a special type of trust, and if set up properly, a special needs trust provides a safe haven where assets or resources can be placed that do not count toward the $2,000 limit. Again, I repeat, if properly established, assets or resources in a special needs trust do not count against the individual that's receiving SSI, Medicaid, Medicaid waiver services, etc. So one can retain full eligibility for all of these government benefits despite assets or resources that they have, as long as they are in a properly established special needs trust. So I often say this is about as close as we can get in the special needs community to having our cake and eat it too. That is, to let the government do as much heavy lifting as possible and to let the resources that we leave to or gift to a trust provide for and take care of those things that the government can't or won't. So through planning, if our loved one with special needs is able to generate income through employment, then they can do that. They can still maintain eligibility for Medicaid and Medicaid waiver services and Social Security. And then in addition to that, they can have assets or resources in a trust. Now, trusts can be funded in different ways. They can be funded with gifts from family members or friends. I worked recently with an individual who has a close friend that has agreed to make annual gifts going forward into the future for their child that has special needs. It's very exciting and encouraging to see that kind of support. Sometimes gifts are made from grandparents or other family members, perhaps holidays, Christmas, birthdays, etc. And again, gifts can be made to a special needs trust without creating any conflict regarding eligibility for these government benefits. So trusts can be funded while parents are still living. They can be funded from other individuals besides the parents, or a trust can be set up and remain empty, waiting on parents to depart and leave assets through their estate plan, through the trust being listed as a beneficiary on life insurance or retirement accounts, or being listed on through their will or through other assets they have, etc. Now, special needs trusts can hold a variety of assets depending upon how the trust is set up. If the trust is an attorney-drafted trust, then the trust can be set up to hold real estate, investments, a variety of property, etc. If the trust is a pooled trust, through an example would be through the Arc of Indiana, then most often the assets held by the trust are in the form of cash, or cash left to or given to the trust, and then in that case the trust is managed through the Arc of Indiana Master Trust. So here in Indiana, we are fortunate in having a variety of options. So one can have an attorney draft a trust, one can consider utilizing the Arc of Indiana Master Trust. Again, different options, and it's a matter of determining based on the family situation what option is the best fit or what serves the family member with special needs the best. As far as what the trust can provide for, as we see on the screen, it can provide for most anything that the government doesn't provide or pay for. It can supplement government benefits, or there are some situations where one may determine that they will opt to have the trust pay for something in lieu of a government benefit. The trust can also provide for equipment if appropriate. Sometimes Medicaid has guidelines as to what or with what schedule they're able to do things, and the trust can step up and fill the gap or the void. Trusts can also be funded as a result of settlements received from litigation. So if one were to find themselves in a situation of having special needs as a result of malpractice, personal injury liability, or manufacturer liability, then frequently there's litigation, and a settlement from that litigation can be placed into a special needs trust to enable the consumer to maintain their eligibility for these important government benefits. All right, let's move on to slide 14 and talk about something, a topic that's been getting a lot of attention lately. And some people are wondering how ABLE accounts compare to special needs trusts. And ABLE accounts came about as a result of legislation passed, the ABLE Act, at the end of 2014. It was federal legislation. ABLE standing for Achieving a Better Life Experience, ABLE. And this law allows qualified individuals with disabilities to have tax-free savings accounts. It is modeled after the 529 College Savings Account program. Here in Indiana, we have the Indiana College Choice 529 Savings Plan, and we now also have the ABLE accounts available here in Indiana. And let's delve a little more into just what these ABLE accounts are and how they might be useful. An ABLE account is limited in regards to the eligible expenses that can be paid from it. It is more limited than what a special needs trust can do. Contributions to ABLE accounts can be for up to $14,000 per year, per calendar year, that is. And so that's a limitation annually. We do expect that number to increase over time, but again, a $14,000 limit. Unlike special needs trusts, you can only have one ABLE account. With special needs trusts, you can have multiple trusts. More than one grandparent can set up a special needs trust, parents can set up a special needs trust, etc. But when it comes to an ABLE account, a consumer can only have one account. Also, the account limit is $100,000, or the beneficiary of the account will lose eligibility for SSI. So again, account balances for ABLE accounts need to be kept under $100,000 to maintain eligibility for SSI. That is not the case with special needs trusts. With ABLE accounts, there is what's called a payback provision to the state. And so when an account beneficiary, an account holder, dies, then the state will have a lien on their ABLE account, and so any remaining balances in an ABLE account, the state will seek to absorb to reimburse them for Medicaid benefits afforded the individual while they were living. And in that regard, it differs from what we call a third-party special needs trust, where there is no payback. So with a third-party special needs trust, the state has no lien, and one is able to direct where balances left in the trust will go at the time of the trust beneficiary's death. Just one other point, there's also what we call a first-party special needs trust, and a first-party special needs trust is typically funded with funds belonging to the individual with special needs. And in the case of a first-party special needs trust, there would be a lien similar to ABLE accounts. All right, let's move on from special needs trust to guardianship. In the state of Indiana, usually as a young person with special needs is approaching age 18, that's the point at which parents explore guardianship. And whether it's an avenue or a direction that they feel appropriate to pursue with regards to their son or their daughter with special needs. And so frequently families are reaching out to me when their kids are turning 17 or that type of thing to kind of get a handle on whether guardianship may be appropriate and what the process is and what costs are involved. With guardianship, one in the state of Indiana puts together a petition, and the petition is submitted to your respective county court. The objective of the petition, which includes medical evidence, typically documentation or a letter from one's personal physician, and the petition, the objective is to request a hearing. The subject of the hearing being guardianship for the individual. And so typically who's requesting the guardianship and the individual for whom guardianship is being requested, along with their attorney, their legal representation. You go to court at the time of the hearing, and the guardianship hearing addresses the need for guardianship, and the judge hears the guardianship case, and the judge issues an order from the bench. So if the judge is in agreement with the guardianship, then the judge issues the guardianship order, and this enables parents to be the legal representative and oversee things with regards to the child that has special needs going forward. In a way, it's from a legal perspective like they do not quite reach age 18. So some parents find this helpful with regards to being able to conduct their affairs, to intervene where appropriate, participate in the IEP process, deal with government agencies with regards to government benefits, provider agencies with regards to services being provided, medical issues, and the list goes on and on. It is a legal decision, and so I always encourage parents to consult with an attorney for the pros and cons involved in guardianship in order to make an informed decision. In the state of Indiana, there is full guardianship and there is also partial guardianship, and then there are alternatives that can be considered in some situations. So full guardianship would be guardianship of the person and their estate, that is, the individual and any funds or monies they may have. If they have no assets or resources, then typically it would be guardianship of the person that parents would be exploring or considering. The alternative to either or both of those is what's called a durable power of attorney and a healthcare directive. And if an attorney that you're working with determines that they have capacity, then the alternative of a durable power of attorney or healthcare directive can be considered. All right, let's move on to slide number 18, and it's, have you identified a care provider? You know, it's interesting. When I started moving my practice in the direction of special needs close to 20 years ago, my experience prior to that time when working with clients on estate planning is that if you have child or children and needed to get agreement by someone to be the guardian for them if something happened to you, then you usually reached out to the grandparent or grandparents, or to your sibling if you're a little older, this type of thing. And frankly, it was a pretty quick conversation. Just kind of like checking in with them if something happens to us, just making sure that you'll take the kids, and perhaps they confirm that you would do the same for them, and within a matter of a few minutes everything was settled and you moved forward. And then special needs. And I found that when that conversation occurs and you're seeking someone to be the guardian or caregiver of a child or dependent with special needs, it's not always a 2 or 3 minute conversation. And so over time, we have determined, in working with literally hundreds, actually thousands of families, that concerns usually fall into two major camps. And one of those is how the expenses or the financial side of things will be handled or taken care of. And of course, government benefits are a part of that, as is a funded special needs trust where planning has been done. And then the other concern they have is how to parent on a day-to-day basis. All of the contacts with government benefits and providers and the medical community and your sphere of friends and support groups and organizations like Down Syndrome Indiana. And routines and schedules, they get them up in the morning and they get them to bed at night, and the food issues and perhaps personal hygiene issues and just all of this. And taking that on can often create anxieties. And so what we have found over the years is that that conversation is aided significantly if there's a planning process underway that will create a special needs trust, and that there's funding for that trust, that there's going to be resources or assets in that trust, and government benefits like Medicaid and Social Security and waiver services are going to be maintained as a result of this careful planning. And then for the how-to on a day-to-day basis, we work with families to create something called a letter of intent or a caregiver guide for the family member with special needs. And we have a fill-in-the-blank booklet that's quite thorough. We also have it as a fillable Word document, and we assist families in putting this together, marshaling the resources and the contacts and frankly most all of the information that family is going to want or need should someone have to step up and fulfill that guardianship role. And so by working to put this together in addition to the Special Needs Trust, it addresses the need to maintain eligibility for benefits, to have a trust that will help fund what the government can't or won't pay for, and then to have detailed instructions in the form of a letter of intent for the day-to-day. So as you can see on slide 21, just about anything can be placed in a special needs trust. Property, investments, retirement funds, life insurance, frankly, whatever you have. Whatever you have, whatever you would like to leave to your son, your daughter, your family member with special needs, most likely we can get it into a special needs trust. It can own a personal residence. It can own a condominium. It can own a vehicle. It can own investment property. There's almost no limit as to what a special needs trust can hold. It can even hold qualified assets such as IRAs or proceeds from a 401k, 403b, PERF, etc. And it's even possible to have multiple beneficiaries where even a portion of these things would be directed to a special needs trust so that other portions can go to the siblings of child or dependent with special needs. Life insurance on slide 22 can be a helpful tool in funding a special needs trust. It's usually free from probate and estate taxes. It can create an estate where none exists. Many families do well just to pay their bills and keep their head above water financially. And so life insurance can create the funds to fund a special needs trust that one might have struggled to accumulate while they were living. Leaves existing estate intact for other family members. So through life insurance, it's possible to provide for the child or dependent with special needs and the others as well. Can be budgeted to meet income needs, provide guarantees, and to help meet the financial needs for lifetime care and quality of life for your dependent. Question number 3. I mentioned earlier that for many of us, most of what we leave for those that we love is in the form of life insurance or retirement accounts. And yet now we see that including them as a beneficiary is a potential problem. And so the very assets or resources that we would think most about providing for our loved one with special needs, we can't leave to them. So this raises a big question. And years ago, when families felt they had no alternative, left assets or resources to siblings or other family members, morally obligating them to do the right thing or to provide or take care of the family member with special needs. Well, when special needs trusts came into being, it really helped solve that issue, so that we as parents of children or dependents with special needs are no longer forced to leave the assets to other family members in order to preserve eligibility for Medicaid and Social Security, etc. We can now leave assets and resources to a special needs trust established for their benefit. And in the process, we can be assured that those assets or resources are going to be used to assist them, not co-opted for other purposes. Extremely, extremely comforting. There are a variety of different life insurance coverages, universal life, whole life, term life, and we can effectively work with all of those to assist in seeing that a special needs trust gets funded. Where there are 2 parents on slide 26, you will see mentioned something called survivorship life, and it is a special type of life insurance coverage that we use frequently in 2-parent situations. It insures 2 people instead of 1, providing a benefit only after the death of the second person. So if the greatest concern for funding the trust is when there's no longer a parental advocate, it guarantees funding at the death of the second parent. And it generally costs less than insuring 2 people individually, so we frequently see a meaningful discount in utilizing that coverage. And I have access to practically every insurance company in the industry that offers that, and help many families find excellent values utilizing that coverage. I think at this point we'll see if there are any additional questions that anyone has, and look to beyond that to wrap up the webinar. So if anyone has any questions, do feel free to speak up or to type something into the chat area, and I'll be delighted to answer questions that we receive. Do we have any questions or comments, for that matter, on something that we've covered or any other related special needs topic? I'm checking to see if anyone's typing. Okay. All right, so I'm not hearing anyone with questions at this point. So thanks to everyone for participating in today's webinar. On the handout that features the young boy on the front with Down syndrome is all of my contact information. I'm always happy to field emails or phone calls, and also to provide a free consultation at either of my offices. We typically set aside 90 minutes for each family. There's a pre-meeting package that is sent out, and there's absolutely no cost to come in and meet with us to address the legal, financial, and government benefit issues impacting your family specifically. Again, thanks to everyone. Take care.